So imagine being in a relationship where you're not just controlled physically, but mentally and emotionally, day in, day out. Your partner monitors every single move, isolates you from your friends and family, controls your finances, and makes you feel like you're constantly walking on eggshells. This isn't just another toxic relationship, it is now a criminal offense in New South Wales. Today, we're talking about the new coercive control laws that could change the way we view domestic abuse forever. First off, what exactly is this coercive control concept? It's a pattern of behaviors used to dominate or control another person by hurting, isolating, fighting, or even threatening them. It's usually seen within domestic and family violence. We're not here just talking about a one-off incident here. Coercive control involves a repeated and ongoing actions by physical and non-physical abuse, such as monitoring, harassment, and unreasonable control over their daily activities. Think of it like a psychological warfare where victims of autonomy and freedom are systematically stripped away. These actions might seem minor individually, but when they're taken continuously, and they can cause serious harms. Under the new Crimes Legislation Amendment, which is the Coercive Control Act 2022, coercive control is now a criminal offense. This law comes into effect July 1st, 2024, amending the old Crimes Act Section 53D, which makes an offense to engage and harass a person in the conduct of consistent abuse against an intimate partner with the intent of coercive control. Now, does abusive behavior mean under this law? It includes violence, threats, intimidation, or any form of coercive control over a current or former intimate partner. To establish such an offense, the prosecution must prove several elements beyond a reasonable doubt. These elements include the accused is an adult, the accused and the complainant were intimate partners, either by currently or formerly, the accused engaged in a course of conduct that's consistently of abuse. So the intention behind this conduct was to manipulate or dominate the partner. And here's how is a clincher. A reasonable person would consider this behavior likely to cause fear of violence or a serious impact on the victim's daily life. Now let's talk about the penalties. The maximum penalty for this coercive control is 7 years imprisonment. That's right, 7 years. That just reflects on how seriously the law takes these patterns of abuse. But remember, this is a relatively new offense, so there's still a lot of questions about how will it be applied in practice. That's why it's crucial to seek legal advice if you're ever charged with this offense. You might wonder, are there any defenses to such a charge like this? Oh yes, there are. The main defense is that the conduct was reasonable in all circumstances, as outlined under Section 54E of the Crimes Act. So what's considered reasonable? This could widely depend on the situation. For example, someone is placing a tracking device on a children's bag because their partner repeatedly breaches family law orders, withholding the child, the court might find that reasonable. Other defenses like duress and necessity, but each case is deepened heavily on the facts. For example, coercive control can range from they all share a common thread of exerting power and control. These can include causing harm, threatening harm, if the demands are not met, which is like financial abuse, like withholding money or restricting to assets, and even more subtle forms like humiliation, consistent monitoring, or isolating someone from their friends and their family. Some of these behaviors might seem normal relationship conflicts, but when they become patterns, they're anything but normal. So they're criminal. Let's bring this into a real life case study that has made headlines across New South Wales, which was a 44-year-old man from southern New South Wales has become the first person ever charged under the state's new coercive control. Less than a month after these laws came into effect, a 39-year-old woman walked into a police station in Leeton, reporting this abuse. The police quickly acted, arresting a partner later that day. The case was significant for several reasons. First, it makes the beginning of a new era of how domestic violence is addressed legally. So this man was charged with multiple domestic violence offenses, which sort of include stalking, intimidation, assault, occasionally bodily harm, as well as this new coercive control. He was taken to the police station where he faced a Wagga Wagga local court the following day. Not only was he refused bail, but the police also applied for an apprehended domestic violence order to protect the alleged victim. Newly released figures show that in the first month after these laws came into effect, police received 23 reports of this control. These incidents vary from various forms of abuse, from threats, intimidation to more severe cases including harming the children or animal abuse. Almost all the victims who came forward were female, highlighting the gendered nature of this crime. Over 60% of these reports involved threats or intimidation, and nearly half included harassment, monetary or financial abuse. These statistics underscore the importance of the new laws and significant role they play in protecting victims from non-physical abuses. It's clear that the introduction of these laws have already made an impact. And what can we expect from these charges to be laid in the coming weeks and months as the police continue to act on these reports? So why has coercive control been made a crime? This form of abuse has been long recognized as a significant factor in domestic violence. It's strongly correlated with the intimate partner homicides. In fact, in New South Wales, domestic violence death review team found that over 112 intimate partner homicide reviewed between 2009 and 2016, coercive control was present all but in one case. This law aims to address those dangerous patterns of behavior before they escalate to even more severe violence. It's also important to understand how these laws will actually interact in family law. A conviction of a coercive control can have very serious implications in family law proceedings, especially regarding children custody and the protection orders. Even if coercive control charge is defended successfully in a criminal court, the evidence from that case can still have much influence in family law decisions. Remember, the standard of proof in family law is on a balance of probability. It's much lower than the criminal one, meaning that the court may still find the contact occurred based on the available evidence. So it's a very crucial point that even without a criminal conviction, allegations of this coercive control can significantly impact family law outcomes. The courts will consider any relevant findings when assessing risks and making decisions in the best interest of the children involved. So if you or someone you know is experiencing this sort of coercive control of any form of domestic violence, it's crucial to get help. These are several support units and services available, which is Lifeline, Men's Line, the Domestic Violence Line, that provide 24/7 assistance. Don't hesitate to reach out. Thank you for watching in, and I hope you enjoyed this new law, and I'll see you guys in the next video.